Okay, so welcome back to the deep dive.
Yeah, good to be back.
We are going to be talking about something today that I know a lot of people find very confusing.
Absolutely. Yeah, it's definitely a topic that causes a lot of head scratching.
And it has to do with something that we see a lot in the material that we've been looking at, and that is debt and debt ownership.
Right, yeah, exactly.
And particularly the way that debt is kind of moved around from one place to another, and then you end up in a situation where somebody is suing you over a debt, and you're thinking, wait a minute, like, who are you?
Yeah, like how did you even get here?
Yeah.
Where did you come from?
Yeah, how did this happen? And, do they even have the right to sue me for this?
Right, yeah, that's the big question, isn't it?
That is the big question. So that is what we are going to try to unpack a little bit today.
Absolutely.
And we're going to be looking at a specific document, as we often do, called Capital One Receivables.pdf. And we're going to be sort of using this as a jumping off point to try to understand what's actually going on when you get sued for a debt that originated with Capital One.
Yeah, because it might not be Capital One that you're dealing with anymore.
Exactly. And that's the part that becomes very confusing.
Exactly.
So let's dive into it.
Absolutely.
So this document, Capital One Receivables.pdf, it talks about something called a receivables purchase agreement.
Right, the RPA.
The RPA.
Yeah.
Can you kind of explain in very simple terms what that is?
So in essence, it's like a big contract that governs how Capital One sells off its debt.
Okay.
So instead of holding on to these debts themselves, they package them up and sell them off to another entity, often a trust.
All right.
And this agreement dictates all the terms and conditions of that sale.
Okay, so that's a really important point.
Yeah,
This is where the ownership changes hands.
precisely. Yeah.
So they're no longer Capital One is no longer the owner of this debt once they've sold it through this agreement. And they actually often sell it to these things called trusts.
Yeah, you'll often see names like Comet or some other kind of, abbreviation or acronym
Right.
that represent these trusts that are essentially set up to hold these debts.
Okay, so it's not just like they're selling it to another bank or another.
Yeah, it's not a one-to-one transfer. It's usually going into this sort of trust structure.
Interesting. Okay. So that's a really important point, I think, for people to understand because, it's not like Capital One is just transferring it to some other company that's now going to be coming after you. It's going into this kind of
This kind of entity, this trust.
yeah, a different kind of legal entity.
Exactly.
And so at that point, Capital One is no longer the owner.
Right. And generally, they lose their legal right to sue you at that point.
Okay, that's a big deal.
It is a huge deal. Yeah.
And this transfer of receivables actually happens immediately.
From what we can see in the document, yeah, it's not some drawn-out process.
Yeah.
The moment that agreement is signed, boom, the debt is transferred.
So Capital One is out of the picture.
As far as ownership is concerned,
Yeah.
absolutely. Yeah.
And then there's a public record of this as well, right?
Oh, yeah,
You
absolutely.
can't just like hide this.
No, they can't sweep it under the rug.
And that's what's called the UCC financing statement.
That's the one.
Yeah.
The UCC financing statement basically acts like a public notice that a sale has happened.
Right.
And that Capital One is no longer the owner of this particular asset, which is the debt in this case.
Okay. And so if that's the case, and Capital One has already been paid for this debt when they sold it to the trust.
Right.
Right. Because they get the money up front.
Exactly. They get the money up front. They're not waiting for you to pay.
So what financial loss are they claiming if they try to sue you later?
Right. That's the big question, isn't it?
Yeah.
Because in theory, they've already been compensated for that debt.
Yeah.
So it's a bit of a head scratcher.
It really is. Okay. So we've got the RPA. We've got the UCC financing statement.
Right.
And then we've got all these other companies that are now seemingly coming out of the woodwork
Right. Yeah. Who are these people?
to collect on these debts. And that brings us to the role of what's called the servicer.
The servicer. Yeah.
So can you explain what a servicer is?
Yeah. So a servicer is essentially like a third-party company
Okay.
that's been hired to manage the debt on behalf of the actual owner, which, as we've said, is now this trust.
Okay.
So they're not the owners themselves. They're kind of like the property manager.
Okay.
They're taking care of the day-to-day stuff like processing payments, handling charge-offs, reporting to credit bureaus, things like that.
Okay.
And yeah, sometimes they even go as far as contacting debtors and, initiating legal action.
Right. So just because you're getting a letter or a phone call from a servicer,
Right.
it doesn't mean that they own the debt.
No, not at all.
They're just managing it.
They're just the middleman.
And so does that give them the right to sue you?
That's a good question, and it's a bit of a gray area.
Yeah.
their authority to actually act on this debt really depends entirely on their agreement with the owner.
Okay.
So if the agreement doesn't explicitly give them the power to sue, then they might be overstepping their bounds.
Right. Okay.
And the other interesting thing here is that servicers can change
Oh, really?
over time. Yeah.
So it's not even like it's always the same company.
Right. It can be a real headache trying to keep track of who's who.
So like, I get a letter from this company and I think, okay, I guess this is who I owe the money to now. And then 6 months later, I get another letter from a completely different company.
Yeah.
And I'm like, wait, what happened?
Right. What's going on here?
And so this changing of servicers that can actually create some real problems when it comes to the accuracy of the records.
Absolutely.
Right? Because if you've got different companies handling this debt over time, there might be gaps in the information.
Yeah, there might be mistakes, inconsistencies, you name it.
Yeah. Right. And that can make it really hard for the plaintiff to actually prove how much you owe.
Exactly.
And where the debt even came from.
Right. It becomes a bit of a mess.
Yeah. Okay, so let's talk about some specific legal strategies.
Yeah. Let's get into the nitty-gritty of how
Yeah.
you can actually fight back.
If you're in this situation,
Right.
because, it's one thing to understand how the system works, but what can you actually do about it?
Right. Yeah, knowledge is power.
Yeah.
And one of the key things that this document highlights is the importance of challenging what's called the plaintiff's standing.
Okay. What does standing mean?
So standing in legal terms basically means that you have the right to sue.
Okay.
It means that you have a dog in the fight, so to speak.
Okay.
That you have a legitimate stake in the outcome of the case.
Okay.
And in the context of debt collection standing, boils down to whether the plaintiff actually owns the debt.
Okay.
Because if they don't own the debt, then they don't have the right to sue you for it.
Right.
So if Capital One has already sold off the debt through the RPA, they probably don't have standing anymore.
Okay. So how do you challenge that?
So the first thing you want to do is demand to see the paperwork.
Okay.
You want to demand the bill of sale and what's called the chain of assignment
Okay.
from the plaintiff.
And what does that show?
This shows the paper trail of the debt.
Okay.
It shows how the debt was transferred from Capital One to the trust, and then from the trust to whoever is suing you now.
Okay.
And if they can't produce this documentation, then you have a strong argument that they don't have standing.
Right. Okay.
Because you're basically saying, hey, prove to me that you're the one who actually owns this debt.
Okay.
And if they can't do that, then their case is pretty weak.
Yeah, that makes sense. Okay, so that's one strategy.
Yep.
There's also something called a motion to compel proof of ownership.
Right.
Can you explain what that is?
Yeah, so a motion to compel is basically you go into the court and saying, hey, judge, can you order the plaintiff to actually prove that they own this debt?
Okay.
And in this case, you'd specifically want to demand those UCC financing statements that we talked about earlier.
Okay.
Because those are public records that show that Capital One sold off the debt.
Right.
And if the debt is now held in a trust, the plaintiff probably can't enforce it.
Okay.
Unless they can show that they somehow acquired it from the trust.
Right. Okay.
So this motion is really about putting the burden of proof on the plaintiff.
Okay.
To actually demonstrate that they have the right to sue you.
Okay, so you're not just accepting their word for it.
Exactly. You're making them show their work,
Yeah.
so to speak.
Okay.
And then there's another angle that you can use, which is demanding proof of what's called consideration.
Okay, what is consideration?
So consideration is a legal term that basically means something of value.
Okay.
In the context of debt buying, it refers to what the plaintiff actually paid for the debt.
Okay.
And a lot of times these debt buyers will purchase these debts for pennies on the dollar.
Really?
Yeah.
Wow.
And so if they only paid 10 cents on the dollar for your debt, you can argue that they haven't actually suffered the full financial loss.
Oh, interesting. Okay.
Right.
So they can't come after you for the full amount.
Exactly. Yeah. You're basically saying, hey, you didn't lose that much money, so you can't claim that much from me.
Right. Okay.
And this can be a really effective way to reduce the amount that you ultimately have to pay.
Okay. So those are some strategies for dealing with debt buyers in general.
Yeah.
But what about if the lawsuit is actually coming from the servicer?
Right.
How do you challenge their right to sue in that case?
So this goes back to that distinction between owning the debt and just managing it.
Okay.
You need to ask the servicer point blank, are you the owner of this debt or are you just the servicer?
Okay.
And if they admit that they're just the servicer, they usually don't have the standing to sue on their own.
Okay.
They're acting on behalf of someone else. So in this case, You want to demand to see proof of their legal right to act on behalf of the actual owner.
Okay, so like a contract or something.
Yeah, a contract that specifically outlines their authority to collect on the debt and to take legal action.
Right. Okay.
And if they can't produce that documentation, then you have a good argument that their lawsuit is invalid.
Okay, that makes sense. And then we talked about how servicers can change.
Right. Yeah, the musical chairs of debt collection.
Yeah. And so if that's happened in your case, there's another thing that you can do,
Absolutely.
which is to challenge the accuracy of the debt itself.
Right.
Because if there have been all these different companies involved over the years, there's a good chance that there might be some errors in the records.
Oh, yeah, for sure.
And so what you want to do is demand a complete itemized payment history from every single servicer that has handled the debt.
Yeah, all of them, every single one.
Yeah, and you want to compare those records and look for any discrepancies.
Right. Any inconsistencies, any gaps, anything that doesn't add up.
And if you find something, you can use that to challenge the validity of the lawsuit.
Absolutely. Yeah, you can say, hey, this doesn't make sense.
Yeah.
You're claiming that I owe this much.
Yeah.
But your own records don't even support that.
Right. Okay.
And that can really throw a wrench in their case.
Okay, so this document, it actually refers to something called the lawyer's argument,
Oh, yeah.
which is kind of like the typical defenses that you might encounter.
Right. The greatest hits of debt collection arguments.
Yeah, from the attorneys who are representing Capital One or these debt buyers.
Yep.
So what are some of those arguments and how can you counter them?
So you'll often hear things like, we do legally own this debt.
Okay.
We have the right to sue you because of this assignment, or the servicer has full authority to collect.
Right.
But the key here is that they have to prove it.
Okay.
They can't just make these claims without any evidence.
Yeah.
And so your job is to demand that evidence.
Okay.
You want to see the original contract,
Yeah.
the bill of sale, the RPA,
Mhm.
the trust agreement, everything. And if they can't produce those documents, you can argue lack of standing
Right.
and even potential violations of the FDCPA,
Okay.
which is the Fair Debt Collection Practices Act.
Okay.
Because if the wrong entity is suing you, that could be a violation of that law.
Okay. So really just demanding that paperwork.
Yeah, make them do their homework.
Yeah, is so important.
Absolutely.
Okay, let's walk through a few scenarios.
Yeah, let's get specific.
Yeah. Just to make sure that people really understand how this all works.
Okay.
So what if Capital One did actually sell the debt to a trust like Comet,
Right.
but they're still the ones trying to sue you?
Yeah, that happens sometimes.
Can they do that?
Well, legally, probably not.
Okay.
Once they sell the debt, they've essentially given up their ownership rights
Okay.
and their right to sue.
So what should you do in that situation?
So you want to demand those trust documents that we talked about.
Okay.
The bill of sale, RPA, the trust agreement.
Okay.
And then you want to file a motion to dismiss the lawsuit for lack of standing. You're basically saying, hey, Capital One,
Yeah.
you don't own this debt anymore.
Yeah.
You can't sue me for it.
Okay. What about if you're dealing with a debt buyer,
Yeah.
and they're claiming that they own the debt, but they can't really show you how they got it
Right.
from Capital One?
Yeah. That's a common tactic, unfortunately.
Then what do you do then?
So again, you want to demand the paperwork.
Okay.
You want to see the initial bill of sale that shows who originally owned the debt, which is probably Capital One.
Right.
And then you want to see every single assignment document
Okay.
that shows how the debt was transferred from one entity to the next until it reached the debt buyer.
Okay.
And if they can't provide a clear and unbroken chain of ownership, then their claim is really weak.
Right. Okay.
Because you're basically saying, hey, prove to me that you actually acquired this debt legally.
Yeah. And if they can't, then what?
Then you can argue that their lawsuit is invalid,
Okay.
and you can potentially even file a motion to dismiss
Okay.
based on lack of standing.
Okay. What if the entity suing you is the servicer?
Right.
But they don't actually own the debt.
Right. So they're just the middleman.
Yeah. What happens then?
So in that case, you need to demand to see the contract or the agreement.
Okay.
That gives them the authority to sue on behalf of the owner.
Okay.
Because as we talked about earlier, servicers don't automatically have the right to sue.
Right.
It all depends on their agreement with the owner.
Okay.
And if they can't produce that agreement, then their lawsuit might be dismissed.
Okay. And in any of these situations,
Yeah.
if the plaintiff just can't prove that they own the debt,
Right.
what's the ultimate legal move?
The ultimate move is to file a motion to dismiss the entire case.
Okay.
You're basically saying, hey, judge, they haven't shown that they have the right to sue me.
Yeah.
So this case should be thrown out.
Okay.
And if the judge agrees, the case is over.
That's amazing. Okay, so let's wrap this up.
Yeah, let's summarize the key takeaways here.
Because I know this has been a lot of information.
It has, yeah.
But it's so important for people to understand.
Absolutely.
So what are the 3 most important things that people need to remember?
Okay, so number 1, you need to understand the process of debt securitization.
Okay.
And how it affects ownership.
Okay.
Because if Capital One has sold your debt, they might not have the right to sue you anymore.
Right.
Number 2, you need to know your legal rights.
Okay.
And the strategies that we've discussed today for challenging a debt collection lawsuit.
Right.
And number 3, you need to be proactive.
Okay.
Don't just ignore the lawsuit or assume that the plaintiff is in the right.
Right.
Fight back, demand documentation, and make them prove their case.
Yeah, don't just roll over.
Exactly.
Yeah. And on that note, I want to leave you with one final thought.
Okay, hit me.
If Capital One has already been paid by investors through this whole securitization process, what right does anybody else have to come after you?
That's the million-dollar question, isn't it?
It is.
If they've already made their money, why are these other companies allowed to sue you for the same debt?
Yeah.
It's definitely something to think about.
It is. And so I encourage you to do your research, learn more about this.
Absolutely.
And really understand what your rights are.
Yeah.
Because knowledge is power in this situation.
Knowledge is power. Absolutely.
So thank you for joining us for another deep dive.
Always a pleasure.
We'll see you next time.
See you later.
Bye.